All right, welcome everybody. We'll get started in about a minute here. Again, we can't see or hear you, so if you have questions, look to the chat for those. And we are recording this, so Beth and I will try to be on our best behavior. And I think, yeah, we're at 9 o'clock, so we might as well just
Let's hit
roll
it.
with it. Let's roll with it.
All right. Wonderful. Well, thanks everybody for attending. And we're so glad that you join us. I know Saturday mornings are usually not when you want to be spending time with your lawyers, but hopefully we'll give you some good information today and it'll make it worth it. So we want to thank you all for attending. And Grace and Cameron are back at the office, spearheading all of this. For those of you who know Grace, she is sadly leaving us. We're happy for her, sad for us. She's moving back to California to be with her family. So our new marketing coordinator is Cameron, and she will be coordinating things from here on out after this last week of Grace's. So big welcome to Cameron, and everybody I'm sure will be talking to her in one way or another soon. So.
Yeah,
So we're talking about tips and myths or myths and tips, I should say, about estate planning this morning. So I want to thank everybody for coming. And let's see. Uh-oh. Well, it worked
now I see
a minute
your
ago.
mouse, or I see your key.
Hmm. You are controlling. Okay. Doesn't believe that
Well,
I
I
am.
know I'm
Oh,
controlling.
there we go.
Oh, you mean you're controlling the
Um,
slides, not
yes,
just
I'm
being
controlling the
controlling.
slides and it hopefully it won't just catch up, but Erica, do you want to introduce yourself?
Sure. I'm Erica Johnson. I have a BS in Broadcasting Management from Northern Arizona University, so I sold radio ads long, long ago. Then I went to law school at DU, and I've been at Amber Keenan Mitchell Johnson for 20, it'll be 21 years this in 2025.
Oof.
So, I know.
Nice. For those of you who don't know me, I'm Beth Mitchell. I went to Drake University for undergrad, DU for law school. I have been Ambler Keenan Mitchell Johnson for 24 years this year. So boy, we've been here for a long
Just a
time.
while. Just a
Just a
while.
long time. Um, there's a little bit of lag in the slides when I'm trying to control them. So apologize for that. I'm not meaning to make you look at my picture longer and longer.
Whatever.
Hmm. All right. There we go. Aha. All right. Cameron and Grace would get mad if we didn't tell you to follow us on social media. We've got some good stuff there. You can follow us on Facebook, Instagram, LinkedIn. We've do some good, interesting posts. And ground rules for today. Since you are not allowed to talk, only us, please put your questions in the chat. We will stop either from time to time or get them at the end. But we will try to get your questions because I think that today will be a good topic, lots of good, interesting stuff there. And between Erica and I, we basically have about 50 years of combined experience in doing estate planning, probate, trust administration. This is all we do. This is all our firm does. Now, as we answer questions today, this isn't specific legal advice for you. All lawyers, I will say, do this differently. Even Erica and I do some things differently. We'll try not to fight today as we talk about things, but I think this is just good, interesting perspective on different things to do and things that we've seen go right and wrong over the years. Some ways that you can really make your estate plan work effectively. Erica, do you want to do the first one?
Yeah, so I've heard and I hear that, oh gosh, I haven't set a consultation because it's just going to be so hard to get ready for that consultation, Beth, and I don't know, you know, I'm going to have to gather up a bunch of information and it's going to take hours to get ready. So I just never make the call. Just got actually my spouse's uncle for the 100th time, saying, "Oh, I need to call Erica. I need to call Erica." And I think the hesitation probably is, I don't know what I don't know. So the myth, Beth, to me is that it's hard. It's hard to get ready for that consultation. Can you help us out there?
Yeah, so actually, it's really very easy. I would say that the hardest part is just taking the first step, as it always is, making that call. All you have to do is call our office. We have very, very friendly people, Megan, Cameron, Grace, who will set you for a 1 hour consultation. We do that either by Zoom, by phone, or in person. We will send you out a questionnaire. It's not super long. That's intentional. We are trying to make it as easy as possible for you to fill in that information. And there may be some questions in there that you don't understand, and that's okay. Just do your best. What that does is it gives us a snapshot into who we're sitting across from in that meeting. And that way we don't have to spend a whole bunch of time saying, and how do you spell your child's middle name? And what's their date of birth? We're not just information gathering. We want to be able to educate during that meeting and talk to you about what your concerns are and your wishes. And so you just give it a shot, right? The other thing that people I think get nervous about is they say, well, I don't have, that might not be the exact balance of this account, or I don't know exactly what that is. That's okay. First of all, I don't want to know your account information. I don't want it. Please don't give it to me. Sometimes I have people try to give me like their safe combinations. I don't want that, right? I just want you to know where your assets are. We're trying to evaluate a couple things, tax reasons, how much is in your retirement account versus your non-retirement accounts. So that will help us to formulate a plan for you. So it should be, we're trying to make it as easy as possible to overcome the fear of setting up that first meeting. And I really do think we make it as easy as we can. It shouldn't be too daunting to fill out that questionnaire. And then you just have to come in and sit down and talk to us. And we're not scared, at least for the most part.
We try not to be.
I'll do this one. Myth.
Sure.
I don't have an estate plan, so I don't have an estate, so I don't need an estate plan. Sometimes people think, you know what, I'm not wealthy, I'm not Bill Gates, I'm not Bezos, so I don't really need to do an estate plan. What do you think about that, Erica?
Well, I would disagree. And I do hear that a lot. I don't have an estate, so I don't need an estate plan. I think we think of estates. It's kind of a silly term, estate planning. And I don't know where it came from, but it well, probably isn't doing us any favors to say we're estate planning attorneys, but we are. Your estate is not just your money, although we do all have an estate, whether we just have the items in our apartment or we own a whole bunch of stuff. We have clients at all spectrums of um, financial assets and things. But once you turn 18, no one can sign financial things for you. We've helped a lot of people's kids even when they turn 18. Beth, do you help people's kids sometimes do the
A
stuff we're going
lot
to talk about here?
Yeah, a lot of kids who are 18, as they're going away to college, right? It's important to make sure that they have powers of attorney. But I also have had clients who are age 18 who have inherited money, 18, 19, 20.
Mm,
Unfortunately, family situations where their parents pass away or they've been left money from somebody. And so I would say, young or aged, right? There's no limit. Once you hit age 18, and you have stuff, it's important, and you have, health, which hopefully we all do. It's important to do your planning.
right. And so I always say an estate plan isn't just about dying and leaving lots of money. It's a group of documents. It has to do with all parts of our life that we hope we don't need for a long time, this estate plan. But if you need it and you don't have it, that's when it's a problem. So we're going to talk about what do we do? What is this group of documents? And some of the myths about those as well. So, yeah, I think that is a myth that it's only for the rich.
hmm Yeah, yeah, I would agree. It's important for everybody to do their planning and to make sure that they've named the right agents to make their medical and financial decisions, all of that good stuff. And that kind of leads into this one.
Yeah, so I've heard Beth, and I remember my dad years ago saying, "Well, my I can sign for your mom," and I'm like, "No, Dad, you can't." I mean, people say they forge their spouse's signatures, but that's different. That is really not going to work long term. So, but a myth that I've heard many times is if I'm married, my spouse has the legal right to sign things for me. Is that true, Beth?
It is not true, Erica. I know that this is shocking that the myths aren't true, but it is not true. You know, Your spouse doesn't have the right to sign things for you automatically. And it makes sense if you think about it, right? Think about your bank account. If you're the only person on that account, no one else can just sign for you. How would that work? Somebody could just walk into the bank and say, no, trust me, I'm their spouse. I need access to this account. They're only going to let somebody have access to that account if they're on the title or if you've done some planning, like a power of attorney, or you have a conservatorship in place. Now, Erica, do you have any opinions about whether or not somebody should have a power of attorney or do nothing and then just go to a conservatorship kind of state?
Well, I think that if you and people will then answer, "Oh, well, we have a joint account," and I'm like, "Well, everything can't be joint." So they'll say, "Okay, so let's say I need my IRA access. Let's say I'm hurt, and my spouse needs to access my IRA. Well, she's my beneficiary on that IRA, but that doesn't give her the right to get in there. So make sure that we also understand here that the myth that we own everything jointly is just not the case. It's impossible almost always. So my take is, Beth, so let's say I have an IRA, Beth, and I get hurt and I can't access that IRA money because I'm incapacitated. Can my spouse just access it?
No, because they're not on the title. They might be a
So
beneficiary, but you're still alive. They only
what is
get
a
that if you're
conservatorship going to do? Or how does she get a conservatorship?
So if there's no power of attorney, and I do want to be clear that the power of attorney is the path of least resistance. That's what you want. You
Okay.
have a power of attorney so that somebody can get access if you aren't able to, right? But if you don't have a power of attorney, there has to be some way to get access. So that's where conservatorship comes in. Conservatorship is where the court actually appoints someone to make financial decisions for someone else. But the thing about conservatorship is it's not fun. Not that any of this is fun, but conservatorship is really, it's not where you want to be. It's a full hearing, right? Somebody has to go into court and say, you know what, Erica, you're not capable of managing your own assets and making your decisions, which is not someplace we want to be. And it's expensive. If you have an attorney do it, it's expensive. It involves a hearing, it involves annual then reporting to the court on how the money is spent, sometimes even requesting permission from the court to get access to additional funds. And so conservatorship, it's there, but it's a last resort. It's not the preferred way to allow somebody to manage assets. Um, and it's not sometimes it's necessary so we have to do it, but if you can plan ahead and do a power of attorney, that allows a couple of different things. One, it allows you to choose the people that you would name instead of the court choosing who would make your decisions for you, um, which I think is a really big deal. And it also allows you to say when the power of attorney would become effective, if it's going to be effective immediately or if
We're
it's
gonna
effective upon incapacity, all of that kind of stuff.
right.
And that kind of leads into this next myth. And Erica, you should do this one because you've had kind of a change of heart on your opinion about this recently, about when powers of attorney should be effective, whether
Okay.
it should be effective immediately or upon incapacity. So I think everybody would love to hear your perspective on that, and I might chime in at the end with the other perspective, but I think you have some real life experience about when powers of attorney should become effective at this point.
So the myth here, that one is that my financial power of attorney must require the agent I appoint to prove my incapacity. Okay. Well, yeah, I would say it doesn't have to. We talk to all of our clients about how they want their power of attorney written, and there are essentially three different ways to write a power of attorney as to when does the agent, the person I'm appointing, have the power to sign for me. Now, first of all, a power of attorney is only good while I'm alive, while the person that signed it is alive. Otherwise, when they die, it dies with them. So remember, this is only while I'm alive. I've signed this power of attorney, and I've given someone the power to sign things for me. The question is, when can they sign things for me? One is that they could sign things for me immediately. That's one option we write. The second one is we could have a power of attorney that's effective only upon my incapacity. That is what in law school we learn about. It's called a springing power of attorney, right, Beth? Does that bring you back a bit there?
It
It
springs into
it
action.
springs into effect upon your incapacity. So, if you have a power of attorney that is a springing power of attorney, it springs into effect upon your incapacity. It needs to define incapacity, which of course ours does at our firm. I've seen people bring in documents I got off the internet that don't define incapacity. That was always interesting. But ours says what one doctor would provide in writing that I am no longer capable of handling my financial affairs, at which point my agent can act on my behalf. Yes, we have one doctor in our financial power of attorney because we don't want to make the hurdle any higher than it needs to be. Also, it mentions here a HIPAA release, which we're going to talk more about, but it's basically that if my power of attorney can only act upon my incapacity, I better have signed a HIPAA release giving that power of attorney the right to talk to the doctors, the right to talk to that agent, okay, with a HIPAA release. So we're going to talk a little bit more about that because that's one of our myths. A hybrid power of attorney says, hey, as to my spouse, this is effective immediately. My spouse doesn't need to prove my incapacity, but if my spouse is gone and my kid is my backup or my sister is my backup, then they can act. And Beth mentioned that it's more of a, I don't know if it's change of heart, but more of a movement by me to try to talk to clients about what is really necessary here or what is most practical, because almost every person that comes in to do their estate plan says, I want this to be easier on my family. And what they're thinking about is when they die, they want it to be easier. But they also would want it to be easier if they're incapacitated. So what's the easiest thing for that agent that I've appointed is to give them power. Make it immediate. Not make them have to go find a doctor who is willing to, first of all, talk to them without the big rigmarole. Second, willing to write a letter. Good luck getting a doctor time to write a letter that says I'm incapacitated. So my push is that if I can get clients to make sure they appoint people they trust and then just make it effective immediately, they have just done what they wanted to do in the first place. Make it easier on the people they appoint. And if you don't have anyone you trust, then there are professionals that we can refer people to. So that's my take on that one, Beth. The myth is that I have to have, I think it's a tradition that lawyers would have doctors have to prove incapacity before a power of attorney was effective.
And I think I see it from both ways. First of all, I will say in a post-COVID world, it's harder to get into your doctor. And so, the period of time that it may take to get into a doctor to get that letter saying that somebody's incapacitated, it can be a while. And if you have urgent matters, that's something to think about. But I also see a lot of clients who have a lot of concern, worry, paranoia about somebody stepping in and taking control before they would want them to. I will say that is more rare, right? I don't see that all the time. I understand that people have heard horror stories, but it is more rare. And I tend to lean more toward the side of these are people that you trust, right? These are people that you trust, hopefully, and you want it to make, like Erica said, you want to make it easier for them. Um, but if it does make you feel better, if you feel like, you know what, maybe the person that I'm named as my agent would jump the gun and they would start getting involved before they should, then you can put in that requirement that it's only effective upon incapacity.
Yep.
Yeah, I mean, it does, I can see both sides of it, and that's why we have different choices, and people can make different decisions. But, when somebody is sick, boy, the last thing that you need is to have to take them around to doctors. And just had a client in last week who said, well, the doctor said that they won't do the letter, that I have to go see, a geriatric physician. And, it can be difficult to get that letter. And so that's something to think about.
Yeah, and I think we would both agree, Beth, that the big key here is appoint people you trust. And if you don't trust them 100%, and if you have any, then you don't appoint them. I mean, that's, yeah.
Yeah, and yeah, if you don't have somebody that you trust, as Erica said, there are professionals, and that may be the route that you need to go. I think it's also good to point out that this this may change over time. You know, when somebody's in their early 40s, you might say, you know what, I really don't want anybody messing around with stuff until I'm incapacitated. So that's my feeling on that. When you're, 90, the answer might be different because at that point you might realize, hey, I need to rely on some other people to be able to help me with some things, and I want to make it as easy as possible for them. So it's
Right, and truly not even incapacitated. My dad
right.
was 93 when he passed, and he wasn't incapacitated, but he couldn't get anywhere. He couldn't do things, so we didn't. If springing power of attorney wouldn't have worked.
Yeah.
You're right,
Yeah,
Beth.
right.
It's a
Because
good
it's not
point.
always incapacity. It's just I need some help dealing with this maze of government, red tape dealing with my TSP in my dad's case, right? Sometimes it's nice to be able to have somebody else step in, and just assist. So, powers of attorney are really a very important tool for everybody to have because you never know when you're going to need it. I'm trying to flip
Next.
to the next slide here.
Okay.
Here we go. Uh,
Okay. So, Beth, this is one a myth I believe that I should just add my children, or that's just the example, right? I don't have kids, but I should just add my children or someone to my bank accounts as owners while I'm alive so they can pay my bills.
so this is one that I think is so prevalent out there. I will have people all the time say, well, that's how my mom did it. That's how my dad did it. They just added us onto the title of the account. And yes, it does give your kids access. That can be good or bad, right? It can be good or bad. Um, the thing about it is, well, you would certainly hope that that wouldn't happen. Adding somebody as a joint owner means that they really own it. It's not just for your convenience. They really actually own that account, which means they could go down and clean out the account, right? Now, hopefully that wouldn't happen, and hopefully you trust them. But the better way to deal with it is to actually use the power of attorney. That's what it's there for. The whole purpose of the power of attorney is to allow someone to step in and get access to your account so that if you are incapacitated, and Debbie, I would define that as a person who is unable to manage their financial affairs, right? If somebody is incapacitated, that then the power of attorney allows that somebody to step in.
Yeah, and Beth, I think we also had a client many, many years ago, not you or I, but one of the other attorneys at the firm, who put their kid on a pretty large account with them, and then that kid got divorced, and that was a part of the divorce. They don't care
Right,
why her name was on the account, her dad's account. So it makes it their money, right, Beth? If I put my
right,
kid on there,
right. Yeah, and think about too if they had a tax issue or a creditor issue or they get into a car accident and they get sued, a judgment creditor isn't going to say, "Oh no, I'm not going to take that money. That's your mom's money," right? They're going to go after anything that they can. You almost have to look at it as you're going into business with that person, right? And I had a client many years ago who as we were talking about the plan, they were said, "Oh, I'm going to add my son onto the title of my house or my bank account." And I said, "Okay, well, tell me a little bit about your son." And he said, "Oh, so mad at him right now. He had to move back into my house because he just got evicted, and then it turned out that he and his girlfriend ran up $20,000 on my credit cards." And he just keeps on, running out of money and trying to get access to my money. And I'm thinking to myself, logically, is this somebody that you should put on your accounts? No, no, right? It's just it can be dangerous, right? But even with somebody that you trust, right? The power of attorney is the better tool because it still protects your assets. You want to be in control of your assets, protects your assets from their creditors. And when we did the powers of attorney, if we've done them for you, you actually have two powers. You have the State of Colorado statutory form, and you have the long form. So you have two of them. One, the short form, it's generally better for dealing with real estate. The long form, generally better for dealing with financial assets because it enumerates all of the different powers, right? It doesn't just say banking, it says at the bank, you can get into the safety deposit box and you can write checks and get copies of statements, all of that kind of thing. And so those do come in handy, and you have to make sure that your agents know where you have those originals. Because Erica, have you had problems like I have where clients they've misplaced the originals, the family only has the copies?
Yeah, and I think we have a myth on that a little more later, more in detail. But yes, or they call and they're like, "We can't get in my dad's safe," and I'm like, "Well, I don't know how to get in your dad's safe. Sorry." I mean, I say it much nicer than that, but it's like, yeah, get some TNT like in the old cartoons and blow the safe open. But I don't think that's an option anymore. It's a problem. So make sure that they have the originals, but I do think we might have a little more discussion on that coming up too. But
Yeah, we should have more discussion because if you are talking to your clients about getting some dynamite and blowing up their safes, I would like to have known about that. I'm
okay.
not
Well,
generally recommending that.
all right, I'll take that out of my repertoire.
But yeah, and don't give away the originals of your powers of attorney. Hold on to those. Give people copies, right? But hold on to those originals. The banks are really sticklers and they do want to see the originals, but don't let them keep them.
They have a
Right?
legal right to see it, right, Beth? I mean,
Yeah.
they. Okay.
Yep, they do. And so a copy won't do. So even if you have digital copies or you have your copies of your documents that you've given to your agents, they still need to know where those originals are. All right. Next one here. There we go. The myth is if I signed a HIPAA release at my doctor's office, my family can talk to my doctors about me. I don't know, Erica, what do you think about that?
Well, just like everyone else, I never read the darn HIPAA that I signed at the doctor's, so I have no idea who I released my information to. If they ask for a contact, I put my spouse, but the problem is in most medical emergencies, I am nowhere near the doctor that I have been seeing for however many years, right? I'm not at that doctor. That is not my doctor in an emergency. So we have all of our clients. Our tip here is to make sure you have a HIPAA release, a separate general HIPAA release, as we call it. And that's what part of every plan that we do. Ours is a separate document. So HIPAA, Health Insurance Portability and Accountability Act, HIPAA, that's a federal law that protects my medical information and your medical information. But we want the people that you've appointed as your powers of attorney to be able to get to the doctors and talk to the nurses and talk to the doctors. So this would cover any doctor in an emergency, or if I probably have a specialist if I'm in the hospital with a long-term thing. Again, I'm not seeing the doctor that I see every year for my physical exam. Okay, I am seeing some other doctor in almost every case, and I haven't signed a HIPAA for them. So our HIPAA release is general. It is important, and it is a part of every plan we do.
Yeah, and I would add that I don't think I'm generally an untrusting person, but I do not trust the hospital to be able to locate a HIPAA release or quite frankly, any documents that I might have signed or even given to them previously. And so that HIPAA release, it's important that your family, your loved ones, whoever you've named to make your decisions, that they have access to it so that they can show up at the hospital with the HIPAA release and say, you have to talk to me, right? I have the right. And the thing about HIPAA is that a lot of times you can kind of fall in the cracks and people will talk to you and they'll release information. But if you run into somebody who is enforcing it, they are right. They
Yeah.
are right to enforce it, and they get fined if they break the law.
Does that
And
include
so,
spouses, Beth? Sorry to interrupt.
yeah, even spouses, right? They can't just release the information. I realize that a lot of times they do because they're trying to solve an immediate problem. But if you run into somebody who won't release the information, you need the HIPAA release, right? The example I always give is, I grew up in a small town in South Dakota. And my dad was in the hospital several years ago, and my mom called to tell me that he was in the hospital and then I couldn't get her. And so I called the hospital where I was born, right, where my parents volunteered for 20 years. I called and said, hey, I needed to know, is my dad there? And immediately they said, sorry, we can't release that information. And I went, I know that. I know that they can't, right? But in the moment, you're not thinking clearly.
Mhm.
So So yeah, that HIPAA release, really important. Make sure your family knows where you keep it so that they can get access to it.
So if I did get hurt, Beth, and I couldn't make my medical decisions, I've had multiple people say, "Well, my doctor will just make the doctors will make the medical decisions." Um, is
Yeah.
is that true?
That is not the way that it works, right? I mean, the doctor takes direction from the patient, just the same way that your financial advisor takes direction from their client. They're not the ones who actually get in there and make the decisions. And so, first of all, if I'm incapacitated and I can't make my own medical decisions, hopefully I have a medical power of attorney that says who would make my medical decisions if I can't. But if not, then there's this law called the Proxy Decision Maker Act. And what happens in that scenario is that my interested people get involved and they come together to make decisions for me. Erica, how does that work exactly? How do those interested people function?
Well, the law says that the doctors or the healthcare people are supposed to find as many interested parties in my life and get them together, and then have them pick what they call my proxy, someone who's going to make my decisions for me. So all the interested parties in my life, which would be a spouse, parents, siblings, adult nieces, nephews, it even says a close friend, they're all supposed to get together, Beth, and agree on who's going to make my medical decisions and appoint that person.
How would that go down in your family? Are they all going to agree as to who's going to be in charge?
On a high time of stress, maybe, maybe not. I just don't want to rely on that. But yeah, everyone doesn't always agree, and it's a very stressful time, right? So I'd rather not take that chance and rely on the proxy decision maker thing. But that's what the law says.
Right, right. Well, and it depends to, families have different dynamics. You have somebody who's really strong-willed, who would want to take charge. You also have complications sometimes between, somebody's parents and their spouse, as to who's going to be in charge. Or you have somebody in the family who thinks that they're really good at medical stuff, right? So there's just a lot of potential there for arguments.
It's fraught.
Yeah. Yeah.
It's
Yeah. What about medical powers of attorney, Erica?
So, yeah, that might be a better idea, right? So, when you become ill or injured, you can't make your own medical decisions. You don't have to rely on the Proxy Decision Maker Act. That's just a stopgap that they said, okay, people, if you're not going to have your own medical power of attorney, we got to come up with something. But if you have a signed medical or healthcare power of attorney, two different names for the same thing, it is a document that allows me to say this is who's going to make my medical decisions for me. Uh, I it appoints that person, and it's effective if needed. If I can't make my own decisions, ours says that if as it is my intent that I am consulted with regard to my healthcare decisions, as long as I have the capacity to understand. Um, and if I don't have that capacity, if the doctors deem that I don't have that capacity to understand, then the person I've appointed can make all of my medical decisions.
Yeah, that would come in handy because it's the person that I get to choose, right? Which is usually what people would want. And if you don't have a medical power of attorney and your proxies are not effectively making decisions, the next step is guardianship, which is the opposite side of the coin from conservatorship, right? Conservatorship is money, conservatorship is money, guardianship is medical. And it would avoid the need for guardianship in most situations. And that's again generally helpful, right? Last thing you want when somebody's sick is to have to try to go to court and get authority to make decisions for somebody.
Right?
Yeah.
Yeah, a lot easier not to have to do that. So you do that as a part of every estate plan, Beth?
Yep, everybody gets a medical power of attorney. You get a medical power and you get a medical power. Everybody
It's
gets a
like a
medical power
car.
of attorney. Because even if you're 18, right, at age 18, now all of a sudden you are an adult and something happens, then your parents who have been helping for a long time wouldn't even have the ability to step in and make medical decisions without doing the proxy or guardianship. And so everybody should have a medical power of attorney. And the nice thing about it is, the doctors and the hospitals and the medical personnel, they just want to know who's in charge. So they're not going to generally mess around with you and make you go find the original or anything like that. They'll take a copy. Copy is perfectly valid. You can fax it, you can email it, you can show up with it. They just want to know who's in charge because they're trying to solve an immediate healthcare situation,
I think they
right?
have a legal right, Beth, to ask for the original if they feel the need, but it's just on a practical level for the medical power. They
Yeah.
often don't require that. Is that
Yeah, because again, they don't want one time in my 24 years has a nurse asked for the original, but generally they're just trying to figure out who's in charge,
for
right?
medical?
Yeah, they're just trying to figure out who's going to be in charge because they need to provide treatment and usually kind of quickly, right? So
Right.
they're usually not gonna make sure that they're gonna make sure that it's valid, but they're gonna take a copy. But there's also this other service called DocuBank. And Erica, I know you in particular, you're a very big fan of DocuBank.
I am. DocuBank is something that you don't have to be a client of ours to use DocuBank. DocuBank is a company that will store medical directives electronically. And if you sign up for DocuBank, they will send you, here's my phone, this is my wallet now, right, on the back of my phone. And the first thing you see when you open my wallet on the back of my phone is my DocuBank card. It's a card that says if you need my medical directives, call the number, get online, and you will get a copy of my healthcare power of attorney, my HIPAA release, my living will, my the people I've appointed, their names and phone numbers. Why is that so important? Well, one, I need to have access. My family does not need to run to my house to find my binder if there's a medical emergency. Okay? They can get to me instead of to my house and then me. And I want that to be easier for them. Again, this is all about making it easier on my family. So if I can enroll in DocuBank for a whopping $100 for 5 years, I think a couple's 175 for 5 years. This is a discount we get for our clients, but again, it's still not that exorbitant if you're not a client. If I can do that and make things easier on my family, that if I'm in an emergency, that stuff can be accessed to prove who's making decisions, who can get my medical information. I don't know why I wouldn't do that. I have no idea why I wouldn't do that. So yeah, I've drank the DocuBank Kool-Aid. I'm a big fan of it. I loved knowing that we had my dad's DocuBank card as he aged, and you know, it just makes it easier.
Well, yeah, because here's the other thing. You would think, well, that information's in my phone, but remember that all of us have a code to open our
No one
phone.
can get in my phone.
Right? So they can't just pull up your contacts. It's not that easy. You have to have some kind of way to coordinate that so that if you are at the hospital that who do they call, right? If there's an accident, they're generally trying to figure that out and it can be difficult, or you can make it easy for them, right?
Even if my in case of emergency is in my without the lock, right? You can get to my in case of emergency, but that doesn't have the power of attorney, the HIPAA release, and the living will. It is not the same thing.
Yeah.
So DocuBank is something you could definitely look into. They have a great website.
They have a great service. And but if you don't want to do that, then I would say for most of our clients, you should have digital PDFs of the documents. You can share your medical power of attorney, living will, HIPAA release, share those with your family. Now, the question is, are they going to know where it is at a time of emergency? Hopefully they've saved it someplace they can find it. That's kind of the hurdle. But that's the other way to deal with that.
Beth, maybe you tell us about this ICE program. We've talked some about having clients whose kids are going off to college.
Yeah, so DocuBank ICE, this is I really like this part of DocuBank as well. Because as kids are 18, right, suddenly they are full-fledged adults, whether they feel like it or not, whether you feel like it or not, right? And so you no longer, as parents, you no longer have the right to make their medical, financial, type decisions. And so we do recommend as those kids are turning 18, have them sign general powers of attorney, medical powers of attorney, HIPAA releases. That the HIPAA release, again, you wouldn't even be able to get access to information about your adult child, right? So it's important to get that stuff done. But then, right, again, the next part is, how do you make sure that it all comes together? Well, if they have a DocuBank card in their wallet, something happens to them, right? They're at the hospital, they're going to see that. And then the emergency contact information is there, as well as the powers of attorney, right? It just, in a time of a crisis, it makes it as easy as possible, which is, again, what you want.
And in the ICE program, if you're enrolling that if a doctor or a healthcare place accesses the kids' documents through DocuBank, that boom, a call gets made to whoever their parent, presumably, that it's been accessed. So now that is the key: is the parent knows and can call and say, what's going on with my kid? And there's the ability to talk to the doctors across the country, where the kid is. Now, somebody has mentioned, do you have concerns that anyone can call DocuBank and get your documents? No, and they are not secure from the public. That's correct. I lost my DocuBank card once. I'm walking my dog and accidentally, being paranoid, I'd carry it with me. And I dropped it, and some lady from down the street called. I have your DocuBank card. No, it's my medical power of attorney, my HIPAA release, and my living will. It's not my private banking information. It doesn't have my social security number. It doesn't have anything that isn't it's not meant to be private. It doesn't work for it to be private. So, but I am not concerned about that because it is a document that is no good to anybody else except for a healthcare person who's trying to deal with me.
I'll add, it doesn't even have your address on it. All it has is your name. It doesn't have addresses of your agents. It's just names. And so they can't do anything.
Get my phone numbers. They could get, but again, if you get on the internet, people, all that's already on the internet. I could tell you a lot about you right now if I just got on the internet. But yeah, it's meant to be public. That's why I don't store my financial power of attorney there, right? Now, they do have a program, DocuBank does, that is separate, where they have a secure portal. But I don't use that, but we could. Someone else, Beth, has a question on here. We have a document titled Authorization. So this is a client of ours. We have a document titled Authorization to Disclose Protected Health Information. Is this the HIPAA release?
It is. That is your HIPAA release, and it should say that you authorize your medical information to be released to. Usually it says if you have a spouse, your spouse, and then the agents under your general power of attorney, the agents under the medical power of attorney. If you have a trust, the trustee of your trust, your attorney, right? We're trying to make sure that you're blanketing everybody who might need access, because again, these are the people that you've named. So I mean, it would have to be a pretty elaborate scheme, right, to get access to your medical information, because they would have, if your medical power of attorney names Erica Johnson, well, then they're going to have to prove that they're Erica Johnson. So it can't just be somebody off the street, right? So I would say that the convenience far outweighs any potential scams.
I have heard absolutely not one story in 25 years with hundreds of attorneys in a national group we belong to that uses DocuBank of any way or any abuse. Not one, because I don't think there's any way to abuse it. So yeah, I think you're right, Beth.
Yeah.
Cool.
So most of you should have, when you sign your documents, we gave out brochures for that. If you're not sure, you could go back in your binders and find that, or you can always contact our office if you want more information about DocuBank. What about this one, Erica? If I have an estate plan, my attorney has done a DNR for me. What is a DNR?
Oh, Beth, the DNR is a do not resuscitate order. It says, if my heart's, in my layman's terms, right? If my heart stops, do not try to start it. Do not resuscitate me. Do not. If I have a DNR, I am telling the world and the healthcare people mostly, do not try to resuscitate me. Now, When my dad got diagnosed in his late 80s with congestive heart failure, and I went over to his house to have the hard conversations about some of the stuff that was ahead, I reminded my dad, I said, Dad, you don't have a DNR. He said to me, didn't you do one for me? And this is when the fear of God hit me that even my own father thought I had done a DNR for him. I cannot do a DNR. Beth, can you do a DNR or sign a DNR?
I can't because I don't have a medical degree. I
Okay.
I only have a measly law degree,
Juris Doctorate does not make us a doctor that way.
not a
So a
medical doctor.
DNR is not something you get from your lawyer. If you have a DNR, it is because you got one from a doctor or a healthcare professional. We have not done a DNR for you. I can't say it enough. You must get that signed by a doctor. It is not a DNR. We're going to talk about a living will in a minute, okay? But a living will is not a DNR. So
And
just know that difference.
yeah, and I would just add, not everybody needs a DNR,
Right.
okay?
Oh,
So,
good point.
for
Yes.
example, I don't have a DNR because if I am in a car accident
You're a
and
baby.
the paramedics show up, I would like them to try to resuscitate me, right? Because I might be fine. So, DNR is something that typically you sign as you age, or if you have a terminal illness, or if you have very strong feelings, right? But not everybody needs a DNR. In fact, quite a few people, I would say shouldn't have one
Right.
yet, right? You make that decision at some point to have that
With your doctor.
with your doctor. And that's why you have to have the doctor sign it because they have to explain the ramifications, right? You understand that that means that if you're in your kitchen and you hit your head and the paramedics show up, that they're not going to try to resuscitate you. Oh, well, perhaps that's not something I would like. Right?
And for
So,
my, 87, whatever year old he was at the time, dad with congestive heart failure, he absolutely wanted a DNR. And he went and got one, But you're right, Beth. Most people don't need one or have one, but whether you do is a conversation with your doctor. So
right.
what is it, Beth, that you've done when people think that, or my dad thought I had done a DNR for him? What was it that I had done for him?
So what we prepare is the living will. And so the living will is where you are saying what should happen in that end of life situation where two doctors have said that you are either terminal or in a persistent vegetative state, and you are unable to communicate, and you are on life support,
You're
right?
already on it, right? You're already on it.
You're already on it, right? So this is you saying when to take it off. Right? When to remove the life support, when to remove the feeding tubes, the IVs for hydration. This is you saying, when they have said that there is nothing more that they can do, when do you want them to let you go? Let nature take its course, right? Because they can keep you alive, right? They can keep you breathing. Do you want them to? That's really the question. The way that I always look at it is, right? So let's say that I am in that car accident and they resuscitate me, they intubate me, they get me to the hospital, and then they say,
There's no
there's
hope.
nothing more we can do. That's where the living will kicks in.
And
That's what
Beth, should I be worried that the doctors are going to say I'm, dying and I'm not really dying?
I wouldn't, I mean, generally doctors are trying to help us, right? And so they're not out to take people off of life support before they should. That's not their goal. But there's a point where if there truly is nothing else that they can do, do you want to be kept alive on life support? This is you letting your family know what you want so that they can act for you. Because in that situation, you're not conscious. You're not directing anything anymore, right? This is your loved ones knowing what it is that you want. And I always encourage my clients that in addition to just signing this, have that conversation with your family. If they are at a place where they actually have to use the power, the living will, it would be really nice if they could remember a conversation with you, where you said what you want, so when they have to use the living will, they can say, I am confident that this is right. I've had this conversation. I feel like I'm helping them fulfill their wishes instead of being shocked as to what do you mean they don't want to stay alive on a machine for 2 or 3 months, right? Which is not what most of us would want, but it's really hard when there is a medical crisis. It's hard to let somebody go. And so that's why you do it.
And to be clear, this is my directive. This is not appointing someone to pull the plug. Because if I hear that, that is the biggest myth. Oh, I don't want to appoint my sister as my medical power of attorney because she's going to have to pull the plug. No, no one is. This is a directive to the doctors to take this decision off of anyone if this happens. If I am truly terminal and not responding, or I'm in a persistent vegetative state, this is my directive. I'm saying when to pull the plug. And honestly, this is probably the least used thing we do, Beth, because why? Most people don't end up on a respirator. This isn't the
Exactly.
movies. This is not the movies or TV. I'm not saying it doesn't happen, and there's people on this Zoom who I'm sorry have had to deal with it, and I'm not making light of it. But it is the least likely thing that we have to use.
It is. And, the other thing that kind of ties in with this is, Erica, I know you're familiar with the most form. Do you want to explain how that
Yeah, and
most
somebody's
form
asked a
works?
question here. Well, first, can there be a joint medical power of attorney? No, each person has their own medical power of attorney. Is the most form in Colorado sufficient? The most form is a Colorado DNR, do not resuscitate order. So when we were talking about DNRs, yes, the type of DNR you would now have in Colorado is the MOST, most form. It says, it's right at the first thing on there, do I want CPR or not? That's a DNR, okay, and among other things. But it doesn't conflict with my living will or advance directive. It it is separate. It does different things, okay? And how current does the most need to be? I don't think it ever expires. So you should know next time you go to the doctor, take it and go through it with them again. But it doesn't expire. Laura asked, you drafted an advanced healthcare directive. That's your living will or advanced directive. That's a living will or advanced directive. Okay, and Beth asked about the most form. The most form is Colorado's. You can Google it. You can pull the form down. All of that has to be signed by a doctor. So you're going to go through that with your doctor. That most form.
All right. Next myth. When I
So,
die,
yeah, go ahead. I don't
my
know what
loved
we want.
ones only need a PDF or a copy of my estate plan. What do you think about that, Erica?
Well, I disagree. Uh, okay, this is what makes me a perfect estate planning attorney is paper is what counts still. We need the paper. We need the paper power of attorney. We need the paper will. We need the paper trust. And why is that perfect for me, Beth?
Well, I have given Erica a hard time for years because she used to carry around her paper calendar. We had to fix that a couple years ago. She did,
No,
she did
COVID killed it.
decide, sorry, she did have to go to an actual computer calendar. But Erica does, she likes her paper. I like my paper too, just not
Right.
quite as much as Erica.
I love it. So, originals are what they need. Where is the binder? With your stuff, tell the people you've appointed and make sure they can get to it. Do not think or say, you can just call the lawyer when I'm dead. No, that they need the documents, okay? They need the binder and the originals, and you can have a PDF of it. If you don't have one, call our office, we'll get it to you. But that's a reference copy. Yes, do we currently keep PDFs of everything, Beth?
We do have
Yes.
PDFs,
Are we going to
but
do that forever? Erica's 58 years old. Do you think that when my clients die in 20 years that I'll have their PDF? I don't
well,
know.
I don't know. I will also say I don't answer the phone at 4 o'clock in the morning when there might be an emergency. And so, or on Saturday. And so the copies, it's helpful, but they need the originals. They need to know where that binder is so that they can get access to those documents.
Yeah, if you
And
don't have your binder, that's a problem.
yeah, you need to make sure that you know where that is. Talk to your family about it. I know that they're not, excited when you're having family dinner and
Oh,
you
they
say,
hate it.
"All right, everybody, here, it's
Here's
all
the
in this
binder.
drawer." And right? I know, but you have to do it. You just have to do it. It's part of planning like anything else. And you can say to them, by the way, this is what's in here. And talk about this, right? So that people know. Um, and kind of that goes along with that, right? When I die, my lawyer's office will have all of my asset, debt information, and my estate planning documents. And I would reiterate on this, as I kind of said at the beginning, I don't have your account information. I don't want your account information, right? I don't know where your accounts are. Obviously, that would be dangerous, right? To have all of your information. So we don't have that. We have your documents, but we don't know. Do you bank at First Bank? Do you have CDs at Belco? Do you have another account at Wells Fargo? We don't know that. And this is probably one of the hardest things that people have to deal with right now because nobody has any paper anymore. Erica can make a face about that. Nobody has any paper anymore. They don't get things in the mail. And so when somebody passes away, it's really difficult, unless you've left information, it's really difficult to figure out where somebody's accounts are. There's no 1-800 number you can call, right? I can't call somebody and say, where are all of Erica Johnson's assets? That would be dangerous, right? So the family doesn't know unless you leave a list. And if it's not, your family or loved one, how likely are they to know? Do you have life insurance? There are a lot of life insurance companies. You can't just call them all, right? Do you have an IRA or 401k? Do you have one through work? Do you have one on your own? Do you have multiple accounts? What's happening more and more frequently these days is that family, loved ones, they don't find the accounts. And after a couple of years, they going inactive, they go to the state of Colorado. And that's not what you want, right? You want the money to go to your loved ones. And so you want to make that list, make a list of accounts, and then put it someplace safe, right? I'm not
We
saying
have
on
something
the
in our
coffee
binder
table.
for them, Beth?
Boy, I think we do, Erica. We have that location list form in your binder that you can use to write down where you keep your paperwork, and you can even do a list of usernames and passwords and all of that. Now, I'm not saying that you have to use the binder. If you have your own system, you don't need to reinvent the wheel, but then you need to tell them what your system is. And if you have a master password program, tell them what the master password is, and that kind of thing. I will a couple times a year get calls from clients, and they'll say things like, the coroner won't let me in to see my parents, body to get the face scan on the phone so I get access. No, they will not, right? You need to leave some information, basic stuff. How do you get into the phone? Our phones have a ton of information in there, but if you can't get into the phone, you're not going to be able to get access to it. And Apple, you can't call them and just say, I need the code, right? They're not going to release that. So you have to leave all that information. Um, and a lot of times too, you have couples, and in every couple there's a division of responsibility. Erica, when it says couple cross training, what do you recommend for that?
Well, I had some clients that told me they called it that. They were like, we're doing cross training. I'm like, what the heck is that? They didn't mean at the gym. What they meant was one knows all the banking stuff and one has no idea or even how to get into the accounts or what the computer is or what bills are owed or whatever. So they were cross training each other as well, because to lose a spouse is extremely hard, as we would all guess and know. And that is, what if they had all the information? Guess what can make it about 10 times harder? That. So, cross-training thinking. I mean, you could really sit down in one weekend, and less than one weekend. You could do it with a drink in your hand if you want, but you want to just start, here's all the stuff. Here's all the stuff that's here or here or here. Just type it all up. And yes, then the next thing, well, it's going to change. Well, 90% is better than 0. So if you want to make an excuse that it's going to change, so you're not going to do this homework, fine. But don't. That's just an excuse. Just get it all written down. And yes, you can have a drink while you. Okay, if you. Beth, when I die, isn't it easiest if I just let someone else decide what to do? Bury, cremate, compost me?
You
Or
know,
just, let them decide.
it's hard because this is stuff people don't want to talk about. I get it. But it's again about making it for people, so that if there is, especially a sudden death, the more that people know, the easier it is, right? And so in all of your documents, you have the Declaration of Last Remains form that is binding, and it's where you tell everybody who's in charge and whether you want to be buried or cremated or composted or water cremation or made into a tree or into a firework or shot into space or whatever else you can think of. But make it easy for everybody. Um, Make it easy. And also it pertains to services. Who's going to be in charge of making those arrangements. During times of grief, this may shock you, but not everybody plays nice. And so, who's in charge of services is a big deal. And it keeps peace in the family to say who's going to be in charge.
I find that if people don't care, I think if people don't care whether they're buried, cremated, or composted, then I will let them get away with that. But then I will say to them, why don't you go ask your whoever it is in your life, right? Why don't you go ask them if they care? Because they may care, and if you don't care, maybe they'll just give you the answer of what they want. So
That's a really good point.
The leaving it up to someone else is not making it easier, and that's what again people say. I'm here to make things easier on my loved ones. I'm like, well, then make a decision, or let them make it for you ahead of time.
Yep.
Beth, we had a quick question here. Death on the pass on payable on death. Raymond Ryan, it's payable on death on financial accounts seems to be an important tool. How does the bank or brokerage account know who to send the money? Well, this is again they don't. So part of what you need to do is if you have the list of accounts, you would say whether they are this account's in the name of our trust or this account is POD to Jimmy or whatever, you would put that on your information. You are telling your loved ones, excuse me, what they need to know about.
Yeah, I think that's a really good point too, Erica. So whether it's a POD or beneficiary on life insurance or something like that, to be clear, your family has to reach out to that financial institution. The financial institutions aren't going to call up your family and say, "Hey, do you want some money?" Right? They don't do that. Your family has to know, the beneficiaries have to know which financial institutions to contact.
That's a better way to say it.
All right. Myth. Is it best if I just put my children or whoever as owners on my house while I'm alive? This is a loaded question, Erica. What do you think about that?
Well, this is the one. Here's my scenario that I always use. You got 80-year-old mom. Dad died, so mom's the only owner of the house. And the daughter is over visiting mom, and the neighbor's dog walker comes by and says, I just heard that you should put your daughter on the ownership of this house so she doesn't have to go through probate when you die. So what does mom do? Mom goes to the store or the interweb and gets a quitclaim deed or a deed, any kind of deed. And yes, a quitclaim deed is a real deed. It transfers ownership, and mom goes and gets a deed, right, Beth? And she says, I'm going to deed my daughter onto the house with me because the neighbor's dog walker said then my daughter won't have to go through probate when I die. You heard it a million times, Beth?
Yeah, I usually say my sister's brother's uncle's neighbor
Right.
likes to practice law and
wants to practice law, and I'm not dogging dog walkers either. Yeah, or you're not dogging the sister's neighbor's brother's neighbor. Whatever all that was. But yeah, I totally. So tell me, Beth, if mom goes and gets a deed and deeds the house to her daughter, what has she just done?
Well, so it's not just a transfer when you die. You're actually putting that person on the title of your house now while you're alive. So all those things that we talked about earlier with adding somebody on the title of your bank account, same thing. They get divorced, they get into an accident, they have creditor issues. That's your house that they might then have access to as a creditor. But the other thing, and the real danger, I think, is the loss of a step up in basis. So step up in basis, when somebody dies, the basis of their property, which is what they've paid for it, plus their improvements, gets stepped up so that the value the date of death value then becomes the basis. So that then when the family goes to sell the property, the capital gain that they pay is the difference between the date of death value and what they sell it for, as opposed to what they bought it for and what they sell it for. And that step up in basis is really important in Colorado and in the Denver metro area because, as you all know, thank goodness, all of our properties have appreciated a lot, right? So we need that step up in basis to avoid the tax issues. Well, when you add somebody onto the title of the house, you're making a gift to them, and they take that gift at the original owner's basis, which means that they only get a half a step up in basis when you die, and the other half they're going to have to pay the capital gains taxes on. The sad truth is that people do this to avoid probate, right? But your average probate is going to cost way less than the capital gains tax would ever cost. Think about how much appreciation you have in your house. Capital gains tax around 20%. You have a couple $100,000 of appreciation or gain in your house. You need that step up in basis. And so adding somebody onto the title of the house, I strongly discourage it, unless it's a spouse. But otherwise, I really discourage it.
Yeah.
And this kind of ties right into that, Erica. If I have a will, that there won't be any probate at my death. That's the myth. And I know people want to avoid probate, but how does a will actually work?
So, yeah, this is false, and that it's not. I think Beth made a good statement there, and that is, it goes through a probate. Okay, it's not the end of the world. I mean, it's just not the end of the world to do a probate. It is a longer process than trust administration, which we'll talk a little bit about. But really, probate is just the way to get assets from a deceased person to the living people. Okay, but a will, the myth here is that a will avoids probate. Okay, it is a huge myth out there. A will does not avoid probate. Bottom line, just wrong. What is the purpose of probate? Again, to change assets from the deceased owner to the new owners, settle creditor claims, but the myth was that a will avoids probate, and the honest truth is that is not the case. There are other assets, Beth, right, that don't go through probate. Some assets, when I die, they're not going to go through probate, whether I have a will or not. What can you tell us a little bit about that?
Yeah, so, everybody does always think it's about the will, and not to discount our very important roles in your planning, but a lot of your planning has to do with how you've titled assets and how you set things up. So remember that if you own something in joint tenancy with someone and one of the owners dies, that interest just immediately transfers to the other person by operation of law, right? So that doesn't go through probate. And if you've named a beneficiary on an account, whether that's filling out a beneficiary designation form on an IRA or a life insurance policy, or you've used a POD form, which is what they call it at the bank, or a TOD form, which is what they call it at a brokerage house, all the same thing, payable on death, transfer on death, that takes precedence over anything that the will says also. So all of those things don't go through probate. It's just the stuff that's stuck in that person's name that we can't get access to, that then the probate is designed to get the assets out of the name of the deceased person to whoever is named in the will. Or if there is no will, then to the intestacy beneficiaries.
And again, we do probates every day, right, Beth? It's not like people are, yeah, a lot of probates going on.
I mean, it's not fun. I mean, I'm not saying at the end, but people
No.
go, that was great. Let's do it again, right? But it's just a process, right? It's just a process that you go through to get access to the assets. Now, can you plan ahead and ways to avoid probate? Sure. And that's what trusts are for, beneficiary deeds, things like that. But it's not, probate avoidance shouldn't always be the most important goal, because sometimes it's the right answer. There's something to be said for having, a judge be in charge of this formal process of retitling assets so that it gets to the right people. Sometimes the Band-Aid approach of trying to avoid probate just makes it worse.
Yeah. Yeah.
When do we have to do probates in Colorado, Erica?
Well, if there's real estate in my name only, or I have probate assets, again, we talked about what doesn't go through probate. And Beth, I was having a brain fade when I did this Probably that's because I shouldn't do these things at the end of my vacation. But is it 86 or is it 80?
It's 86. This was the
Okay.
only thing they changed. It's
Oh,
86.
you changed it. I had the wrong
Yeah.
number. See, I was like, jeez, end of my vacation. I don't remember what the number is. But okay. Anyway, so there are certain state situations where we have to do a probate. Again, we do a probate.
But if the total assets are under 86,000, and
Car.
that excludes things that are held jointly or that name beneficiaries, just what's stuck in that person's name. If it's less than 86,000, then it's a small estate. And there's a process in Colorado called a small estate affidavit that can be used to get access to those assets. If it's more than 86,000, and that's a cumulative total, right? All of the cars and bank accounts and things, then those assets have to go through probate, just the ones that are stuck in that person's name.
Right. And I think we have about 6, 7 minutes. I should make my loved ones beneficiaries on every asset I own. So Beth, this is kind of the same idea.
Yeah.
What if I have everything I own set up POD, TOD, beneficiary? It's going straight to them.
Right. And that can be good and bad. It depends on your situation. And this is why we always say estate planning is not a one size fits all thing, right? In some situations, that might be a good thing. You know where it really doesn't work is where you have, like, say, 4 beneficiaries or 4 kids, and you've left everything to this one saying they're going to share with their siblings. That's not the right way to do that, right? So you have to make sure that the beneficiary designations are being used appropriately. And Erica, there's also some issues with paying bills and things, right?
Well, yeah, it's not that we don't trust them to share the money. Honestly, I don't care. But it's who's in charge. They all look at each other like, well, you pay the bills. No, you pay the bills. No, you pay the bills. I mean, I've seen this hundreds of times. It's a pain. There's no one in charge. Probate puts someone in charge, or a trust puts someone in charge. Okay, so just know that this making everything directly payable to your peeps is not necessarily doing them any favors.
And I think Eric and I are going to be doing a separate little, maybe 3 or 4 minute
Oh yeah,
webinar thing about this coming up. So stay tuned, and you can also look on our website for that coming up.
we have videos on our website. Yes, if I have pets, Beth, the cats who have not yet shown up to the presentation today, I need to leave a pet trust for them. I don't
Actually,
want
Gus did
to run out of
nose his
time.
way
Oh, he
in a few
did?
minutes ago. Now the door is open, so I'm hoping there won't be a lot of noise out there. But he nosed his way in, but he didn't jump up on the desk. For those of you that don't know, you can see a picture of Gus, my cat, on our website. He's adorable, and he really likes to be on Zoom. But if something happened to me, of course, I'm worried, right? Just like Eric would be worried about Hazel, like all of you be worried about your pets. I want to make sure they're taken care of. But should I do a pet trust for them, Erica?
I don't think it's necessary for most pets to create a pet trust. Often it'll just say, hey, well, especially Hazel, our mini golden doodle. I mean, people are going to be fighting over who's going to get Hazel. So I'm not creating a pet trust, Beth. I don't even have in my trust, hey, they get this much money when they take Hazel, because I don't think it's necessary. But you can write that into the will or the trust. Is that right, Beth? If you want to leave money
Yeah.
with whoever takes the pet?
Exactly. And I think that it's helpful to use, actually preferred to use the personal property memorandum for your pets, because remember, your personal property memorandum is something that you can change yourself throughout your life. And
Right.
who you would name to take your pets will change over time, depending upon, let's say they get a dog that doesn't get along with your dog, or they move.
Mhm.
So that way you can just update it over time on your own. And you can always build in something that says, yeah, and you can have some money for taking care of my adorable pet.
There are going to be a bunch of taxes owed when I die, Beth.
You know what? This used to be a big concern, and honestly, it's just not as much of a concern anymore. Just to give you some perspective, back in the 90s, the estate tax exemption amount was, 500,000, 675,000. The current estate tax exemption is now $13.99 million. So if your estate is under that, you don't have to worry about taxes.
Okay, I'm clear.
If it's over that, good job, and we'll deal with it, right? But yeah, most people just don't have to worry about it anymore. Now, that's not to say that, if you're close to
Oh,
that amount, that there aren't some additional planning things you should do. Obviously, we can help with
oh
that.
yeah. And we have
But
clients, Beth, sorry to interrupt. We have
yeah,
clients, right, that have that size, those size
yeah,
estates or bigger. And
yeah,
we deal with that. It's just that most people don't
yeah,
have to.
yeah. All right. Myth, Erica, if I want to leave money to a minor child, I should just leave it to someone and ask that person to use it for the child.
Well, I disagree. I'm not saying, again, it's not that I don't trust my nephew to use the money for his daughter, who is 3, but it's really not his money. I don't want it to be his money because then if I leave it to Michael to use for Martine, his daughter, what if Michael dies? Well, it's not pegged for Martine, right? And nobody knew that. So what we do is often, right, Beth, we have a trust for Martine in my trust. It says, when I die, set up this trust for Martine. This money's going to be in trust for her until she's whatever age. And I say Michael is the trustee of that trust. He's not his money. I set up a way to do that. And I think that's a very important thing to do when we're leaving assets to a minor child.
That's the right way to do it, right? It protects the money for that child, make sure that it's there for them, protected until they reach a certain age.
Beth, what do you do if you have a change to your estate planning document that you want to make? Don't you just
I
initial
just I just get out
initial
my
it?
crayons and I start crossing things out. I mean, I don't think it'll come as a surprise to anybody that, that is really not the right way to do it. The documents that you have are witnessed, they're notarized. You can't just go start crossing things out, and initialing isn't magic, it doesn't just
Hmm.
make it legal. So plus, here's the thing, we don't know what you're going to write. I hate to say it like
Yeah,
that, but we don't know what you're going to write, and we don't know if it's
you're
going to
not
make
an
sense,
estate
and we
planning
don't know if,
attorney.
if it's going to be illegible even. I had a client who was 103 and she wrote something in the margin. We didn't know what it was. And so the better way to do it is to have your documents formally changed, witnessed, notarized, all of that. Don't just leave us a message, saying that you want to change it. You actually have to sign something, right, Erica?
Yeah, just had it. We're all going on a plane. What if we all die? And I know they left that message thinking that that was going to take care of things. Well, one, I was on vacation. I was on a beach, right? And two, it wouldn't have changed anything. So just plan ahead, way ahead. Because if you start planning your trip to Europe and you think you're going to need a change before you leave, then when you start planning that trip a year before, start planning your estate planning changes. Honestly.
Yeah, I mean,
So
I would say this. We would love to be able to just whip something up really quickly in a few hours, but we can't. Our schedules, we're very lucky to be very busy. And so it takes us weeks. You might say it's
if
just
not
one little
months,
change. It
if
takes
not
us
months.
weeks, to get that done, get you in, all of that. So plan ahead. Plan ahead.
All right, we're close to the end of our time, or we are at
There
the
we
end.
go.
But since the last one here, I think, and then we have questions, we'll take the questions. Since I have a pour over will, my trust doesn't need to be funded. Is that right, Beth? So when I have a trust, which I do, I have a pour over will that says, "Hey, pour everything in my trust." So I'm good, right? I don't need to put anything in my trust while I'm alive.
Oh, if it was only that easy, right? It's never that easy, right? That's why when we signed your documents with you, if you have a trust, we spent time going over the assets with you, talking about how to transfer assets into the trust. There's a document that you have in your binder called Living with Your Living Trust that says what to do with each of your accounts. We specifically took time to look at how you should name the beneficiaries on your IRAs and 401ks and life insurance, so that it would all go into the trust and fund your trust. Remember that if on your date of death you have more than $86,000 in assets in your name or any real estate in your name, it will trigger a probate and then the will takes over. So the will, right, is there to get the assets into the trust, but you'd still have to go through probate to get them there. Or you can do the work ahead of time to make it easier for your family. And that's the way that I always look at doing a trust, funding your trust. You're taking it on ahead of time to make it easier for them later, so that they don't have to run around and retitle everything and do a probate and all of that.
Look in the binder. It's living with your living trust.
Yeah.
Okay,
Yep.
before you Yeah, because you're going to find the answer there faster than you're going to be able to get it. I mean, we're here if you need us, but start there.
Yep, start there, and you should have some directions. And there's even a tab that says beneficiary designations.
There's
And the only thing
suggested.
that's behind that is the suggested beneficiary designations for your IRAs, 401ks, life insurance. So it's super easy to find. That being said, if you have not looked at those in 7 years-ish, it's time to look at them again. Because laws have changed, and so there may be different recommendations at this point. And that's why we do recommend that you review your estate plan every, 5-ish years, right? So there may be changes in your family, changes to the law that might impact how those beneficiaries should read at this point. Okay, in the interest of time, well,
That
I
was,
think
we're there. We're
we
there.
are there.
Although we have a
Um,
bunch of questions, so Beth, is
yes.
it okay that I read these? And those that need to log off, we understand. It's a beautiful Saturday morning. I'm just going to hit a few of these questions, Beth. Our
Yeah.
estate plan was prepared. Our estate plan was prepared by you in Colorado in 2022. We've since moved to Florida. Are documents valid in another state? What should those folks do, Beth?
So it's not that they're invalid. I want to be clear about that. But you should always have documents reviewed if you move to a new state, especially the medical stuff. It is different state to state. But even with trusts, wills, you should
Florida.
have documents controlled by the state where you live. And so you can talk to an attorney in that state. If you don't know one, you can contact us. We, as members of the American Academy of Estate Planning Attorneys, have some resources for you. We can send
Maybe.
you to somebody in that state.
We'll try to. Yeah, so take them to an attorney in that state and have them look at them and give their advice. And my plan, the next one is kind of similar, but my plans were done by you in 2017. I need to do an update. Is that so? Is it so, Beth?
Well, I don't know.
How
I
about
don't know. It
I need to do
depends.
a review.
Yep, you need to do a review. A review would be good. Like I said, every five-ish years, 3, 5 years or something big happens in your life, we recommend that you review your documents and let's see if something needs to be changed or not.
And then I was, when my mom died in Denver, I had to provide last remains wishes for her cremation. Is this no longer a requirement? Well, no, it is. That's what we were saying is we do a declaration of last remains so that people do present that to say this is what they wanted. This is a legally binding written document. If someone asks, added a name to a house, I'm asking for a friend, is kind of what she's saying. This is funny. If someone added a name to a house, can they change it back? I would say you'd need to ask a CPA about, I mean, what the IRS would consider a reasonable amount of time to change that back. So I'm gonna put that to a tax person about the capital gains taxes, which is not Beth and I. Should we look for a professional personal representative? We have no close family here in Colorado. If I die in an accident at the same time, our current personal reps are now out of state. Beth, what are their options? What are the
The world is a lot smaller than it used to be. I'll say that. And so just because somebody's out of state does not mean that they can't do this, right? Yes, would they have to travel here to clean out the house? Yes. But can you
that
pay
was what the
bills?
one thing they mentioned, Beth, sorry
Yeah.
to interrupt, was cleaning out the house. Could they hire someone though?
Yep, you can hire somebody if they don't want to do it, or but they can pay bills from anywhere in the world, right? And so they don't have to be here to do that. And we also have lots of resources, right? We know people who will help clean out the house. We all realtors, all kinds of people. So they can also get resources.
Okay. And are we going to have a recording of this,
We
Beth?
are recording. We are live recording, and it will be posted on our website. I would guess next week at some point.
Okay. And then Walt mentions some Medicaid stuff. Walt, you're right. Putting people on properties could affect people for Medicaid. We are not Medicaid attorneys, so when people start talking about Medicaid, we are going to refer them to a Medicaid attorney. And if you have a need for that, you let us know. We'll refer you to somebody who does Medicaid, okay? Because that is not our area and we don't step in that area. But be careful about moving assets around, as Walt's. Hi, Walt, by the way. Well, it's married to my cousin. Okay, current estate tax exemption is expiring. Is this in the big beautiful bill? Yes. The big beautiful bill has an extension, if passed, of the estate tax staying at 14 million ish or higher. When I die, our trust split into two, one for each of my beneficiaries. Wouldn't that be depend? Go ahead, Beth. Or how are the distributions equal? I
Sorry,
think,
I'm going to go backwards 1 second. I'm just
yeah,
going to
yeah.
say, not to be political at all, right? But as I always tell my clients, I'm not in Congress. Congress does not listen to me. Whether or not the big beautiful bill will pass, I
Right.
don't know. What the estate tax exemption amount will be, I don't know. If you're concerned about it, that is something to talk about your specific situation, right? So I wish I could give you a better answer on that. We're gonna all just have to wait and see on the edge of our seats what happens. Um, and then Kathy, when I die, our trust split into two, one for each of my beneficiaries, or how are the distributions equal? So it's hard to I
It's
think
too
understand
specific.
exactly, but it sounds like you're saying, okay, when I die, I have two beneficiaries, and so it splits into the two of them. So that's how it's equal, right? It's 50-50 to the two of them,
Well,
and
if
then
it's
maybe
written
there's
that way, right, Beth? I mean,
yeah,
we have, yeah.
yeah.
But
If
does
it's
it
written
stay in
like that.
trust for them? We don't know. It depends on how it's
Yeah.
written, right?
Yeah, so but we'd have to look at that and see. That's generally how it would happen. Yeah.
Yeah.
Um,
Okay. Yeah, I think sorry, that one's a little too specific. There's a question here. Greetings from Italia. Greetings. Uh, Beth, are you going to Italy?
I am going to
Well,
Italy
maybe
in
these people here,
September.
they're in Italy.
Where are you
Uh,
at? How am I not seeing this?
I'm on the Q&A now, and
Oh,
Beth is going to be in Italy, so maybe she needs to come and see you. But you two can work that out. So I think we've hit most of them. There's some stuff about organ donors, and you would want to look on the organ donor website of the Colorado Donor Alliance for questions about harvesting organs and how long it takes and whether people are kept alive on life support to harvest those. And the Donor Alliance is where you're going to want to go for that information. They're a
okay.
great organization.
Yeah.
So, a couple other pretty specific questions. Well, I think we covered most of them. Oh, can your daughter, as an MD, sign a DNR for you? I don't know. I mean, you'd have to ask your daughter.
Yeah,
I
I
don't.
would say just in an abundance of caution, I'd probably have your,
Different.
yeah, somebody who's not in your family,
I don't know that that's a requirement.
but I don't know.
Please answer my question. Very important. Ray, partnerships and other assets do not have titles. What is the event or process to transfer ownership? Well, we don't want the estate to have to pay income tax. Well, a will or a trust, I'm not a tax attorney, so I'm not sure I understand your question, Ray, good enough to answer it. Sorry, and I don't want to hold up 80 people. Sorry, Ray. But if you want to, if one of us is your attorney, you can reach out to that specific attorney.
Yeah, I mean, I would just say, generally when as your attorney, we would have talked with you about that. You can assign partnership interests into the trust. They can use the assignment and nominee agreement. There are different ways to transfer partnerships and corporate entities into the trust. But in terms of the income tax
Right.
ramifications, that's not, well, I will just say this. You can talk to your CPA, but it is what it is. If you've died and you
Right.
have an entity that produces tax, it's or that produces income, there's going to be some income tax.
Oh, I see what Ray's probably saying is how do you get it out of there faster than not to move it through here to here to here so the
Mm,
income is less likely going to the estate.
to the
Ray, if that's
estate.
what you're saying, then yes, it would just be a process of, well, you have a waiting period if there's a probate. You have time that's going to have to pass. There will probably be some income implications, but you should talk to the CPA who's helping with the income tax returns for the estate. They may have an answer of how to lessen that hit. Sorry, Ray, I wasn't trying to blow off your question. It's just we can't give specific legal nor tax advice about a specific estate, and it sounds like that might be the case right now. So, all right, all look at that, we did it. 10:28. Boop, boop.
Yeah, we talked a little bit too long, but we appreciate all of you putting up with it. I mean, imagine that lawyers who like to talk.